of law in the court's application of the waiver standard, which it used as a basis to deny the claimant his right to pick Tom Winters as a one-time change physician. The third, we assert that the judge of compensation claims erred in finding waiver on grounds that was not supported by competent substantial evidence. With respect to the claim for TPD benefits, we also raised 3 points on appeal. The first, we argue that the court erroneously relied on inadmissible hearsay evidence as the basis for the misconduct finding, which ultimately served as the basis for the denial of the TPD benefits. The second point, we argue that the court erroneously applied the misconduct standard. And on the last point, we argue that the court's finding of misconduct is not supported by competent substantial evidence. Now, turning to our first point on the one-time change issue. In this case, the JCC erroneously concluded that the claimant waived his ability to choose the physician of his choice based solely on the grounds that he attended 2 appointments with the employer-designated physician while he litigated his claim to hearing. In workers' compensation cases, generally the ability to choose the authorized physicians rests with the employer carrier. 441.32F provides a limited opportunity for an injured worker to request a change of physicians.
Let me make sure I understand the timeline here.
Yes, Your Honor.
The petition for benefits requesting Dr. Winters was filed on March 27th, if I'm correct. The carrier designated Dr. Royce on March 30th, and then also sent a letter with an appointment April 3rd for an appointment for April 20th, if I'm correct on that.
Yes, Your Honor.
And it looks to me like you sent an email
Your Honor,
on April 12th.
The initial request for the one-time change was done by fax correspondence.
I know earlier. I'm going on from people. I have the earlier stuff down. I'm trying to get down.
I understand.
From the petition for benefits time, trying to get in my mind what went on.
Yes. So within about a week following the petition for benefits, they sent an appointment letter to the claimant. And the claimant responded on April 12th, essentially indicating expressly, and this is an email to counsel for the employer carrier, which was stipulated as received in the record on page 158, essentially saying that we do not accept Dr. Royce as a change of physician. And it was subsequent to that that the claimant did indeed attend with Dr. Royce.
Okay, did he attend the appointment? I can't find this in the record. Did he actually attend the appointment on April 20th?
I believe it was on April 20th, yes, Your Honor.
Okay, because I know he treated with him twice, and I know he treated with Dr. Royce on May 30th. I was trying to determine whether there was anything specifically in this record that indicated that he went to the April 20th appointment.
The evidence as far as him attending is simply from the DWC 25s and medical notes in the records. And I don't have the first one. I know the second one was indeed in May. Both of the appointments that he attended were following essentially the point in time where the claimant named the physician of his choice and expressly conveyed an objection to
was there any other communication from the time the appointment was scheduled on April 3rd until the appointment on April 20th, other than the email on April 12th?
Yes, that email on April 12th was the objection to Dr. Royce.
Okay, there was no other communication between the carrier and the...
No, Your Honor.
Till the appointment. Okay, that's what I was trying to get clear in my head. Thank you.
Absolutely, sure. And so that takes me back essentially with the waiver and acquiescence doctrine. We've explained the cases, essentially the evolution of that in our brief, essentially starting with the case of Crenshaw and all the way through Pruitt.
What though prevented you from putting in that email, we expressly do not accept this, but my client's going to attend on the 20th, but that's conditional on our objection. You would agree with me that's not in the email on the 12th.
I do agree with you, Honor. That's not in the email. But what we've looked at in the cases as far as Crenshaw, Pruitt, essentially is whether the objection is adequately voiced. And I believe that that particular email did indeed convey the fact that we don't agree that that's the proper physician.
But wouldn't it be fair for the EC to assume, we have the email on the 12th, but then your client shows up on the 20th, well, gosh, maybe they no longer have an objection to this physician? I mean, wouldn't that be a
Fair point, Your Honor, but what I would say is that prior to him attending with that physician, we also filed a petition for benefits, which placed that matter in issue. And as the claimant testified at trial, essentially on the record, that he felt that he had no choice but to attend with Dr. Royce. He did not have any other authorized medical care. He testified that he was in pain, he needed treatment, and that he didn't have the ability to pay for treatment out of pocket. So in that essence, Your Honor, I think it's directly in line with what's been required by the cases of Crenshaw, which essentially look at whether and when the claimant conveyed an objection to the carrier's conduct, whether and when the claimant brought the issue before the court. In this particular case, we had filed a petition for benefits prior to him attending, and also the conduct that occurred since then. You'll see in the Pruitt case, they looked at a couple factors, including the fact that the claimant had never named his physician all the way up through trial, the fact that the claimant attended a mediation at which there was an agreement entered which suggested that the issue was resolved. In this particular case, we went to mediation, no issues were resolved. The pretrial stipulation, the claim for one-time change of physician was still an issue. So at no point before or after did we expressly assent to this. The only evidence that they have of any that may support a waiver finding here is the simple fact that he attended, and it's our position that that alone cannot be dispositive on the waiver issue.
If we accept your position on acquiescence and waiver, that you did not acquiesce or you did not waive your one-time change of physician, would it be appropriate for us to just reverse and tell the JCC to appoint Dr. Winters, or would it be appropriate for us to send it back because the JCC never reached the issue of whether your initial
Well, Judge, we believe that the
was
findings.
sufficient?
Yes, Your Honor. Well, we believe that the findings in the record are sufficient to warrant entirely reversal of this particular point. The record demonstrates that the claimant made several objections, and that was actually expressly noted by the judge of compensation claims in his order on page 22 and 23 of the record. The judge there noted that in no particular case up to this date has any particular injured worker objected to the employer carrier's conduct and named the physician of their choice prior to attending. So those findings, which we believe are pertinent and essentially dispositive in this case, are already contained in the record. And so for that reason, we believe that reversal on that point is required with instructions on remand that the court appoint Dr. Winters as an authorized physician.
Okay, the other side has argued in their brief that we should not consider the deauthorization cases.
And I assume you're
Can you
referring to
address
the
that?
self-help cases in Perotti. And what I would note in that regard is that that should not be the sole remedy for an injured worker in this particular situation. And that is because Perotti and the self-help provisions are a far cry from essentially a worker being able to obtain treatment that's facilitated and coordinated and paid for by the carrier. There's absolutely no guarantee that an injured worker is going to be able to avail themselves of the self-help doctrine, which assumes that they're able to pay for the treatment out of pocket or that they're going to be able to find a physician who's willing to treat them at reduced workers' comp fee schedule contingent on a later adjudication by a court. What we think is that these assumptions are uncommonly satisfied in practice, and as demonstrated by the very record in this case, the claimant here felt he had no choice. He wasn't able to pay for it out of pocket. So what we ask the court to do today is clarify the standard articulated in Crenshaw and essentially state that if a claimant does indeed name the physician of their choice and expressly object to the designation by the employer, they can avail themselves of the authorized treatment in addition to potentially having to fall back on the self-help doctrines, which we note can be problematic. The self-help doctrines not only create those practical issues, but they can also increase additional unnecessary litigation over the bills, and also they put the claimants in a potential position where they can be financially liable for those bills if they don't get a favorable ruling at hearing. And so I think I've covered essentially our points on the one-time change issue as far as a matter of law. I'd also note that based on what we have as far as Crenshaw and Pruitt, we feel that the element of waiver and acquiescence, waiver and silence, or inaction by the claimant is totally absent from the record here. In fact, it demonstrates just the opposite, and as I articulated a moment ago, the JCC noted expressly that the claimant had indeed named his physician and objected prior to attending with Dr. Royce. So we believe that finding is erroneous as a matter of law and also an abuse of discretion. And I'll be turning to my next point, Your Honors, on the issue of the misconduct finding, which essentially, in this case, the JCC concluded that the claim for TPD benefits was barred on grounds of a misconduct defense following the claimant's termination based on a purported positive alcohol test. And the problem in this case is that at no point during the hearing were the laboratory alcohol tests admitted into evidence. Instead, what the employer attempted to do in this particular case is elicit testimony from lay witnesses who had no personal knowledge of the test results, and we objected to that on grounds of hearsay. And that leads me to the case of McKenzie, which essentially dealt with the Unemployment Commission denial of benefits on a misconduct offense. Misconduct is defined essentially mirroring the statutory definition of misconduct in workers' compensation cases, and that's why they look to those for guidance. In that case, the employer failed to admit the laboratory test results, and the court expressly held that for an employee's positive drug test report to constitute competent substantial evidence to support a finding of misconduct, the lab report must be admissible as an exception to the hearsay rule. The test results first came up during examination of the claimant. In this case, we objected to hearsay. The judge said, you know what, I'm going to allow this for the for the limited purpose of establishing the subjective basis why the claimant was terminated. The court stated expressly he's not going to allow the carrier to use the testimony of the claimant to establish the fact and issue pertaining to the test results. That's on page 107 and 108 of the record. And this very issue came up again later when they called the employer representative, Becca Martinez. Essentially, again, they asked her about the test results. We objected on grounds of hearsay. Again, the judge says, I'm going to again allow this for the subjective basis why they terminated the employee. We don't necessarily agree
Counsel, that objection was not a standing objection, correct?
Yes, it was not.
And so you know where I'm going with this. Right after
Yes,
that, he said, were the tests positive? She said, yes, they were, and there was no objection.
Correct, Your Honor.
How do you get around that? And if you, while you're at it, address the effect of the claimant's admission that the tests were positive, because he admitted that he was taking NyQuil to explain the positive test results. So we have two pieces of evidence substantiating the positive test results.
Well, two parts. I'll answer your first question. With respect to the standing objection, Florida Rule of Evidence 90.1041 states that if the court has made a definitive ruling on the record admitting or excluding evidence either at or before trial, a party need not renew an objection or offer of proof to preserve that claim for appeal. So in that regard, we take the position that a standing objection was not necessary. We received a definitive ruling on our hearsay objection. The court said it was going to come in for the subjective intent. We believe that another objection was not required when that question was asked literally 2 questions later. I believe the policy behind that rule is to avoid disrupting the proceedings and, in many instances, angering a fact finder. In our cases, we're actually dealing with a judge and fact finder, the same person. So we believe that that objection was indeed preserved. With respect to the claimant attempting to, explain the positive test results, we would note that from a competent substantial evidence standpoint, even if that comes in, that these test results were positive, it does not support the court's finding that these test results were positive for alcohol intoxication. And that's exactly what the judge noted on page 16 of the order. The explicit policy that he purportedly violated in this case was a substance abuse policy. The employer representative testified that it prohibits intoxication on the job. Mere testimony that the test result is positive does not describe the levels of the alcohol detected on the test or the significance of the levels detected on the test, the chain of custody, any of those things that would be required to give an inference that he was indeed intoxicated on that date. And in addition, there is no testimony.
A minute and a half.
Thank you, Your Honor. With that, I will reserve my time for rebuttal. Thank you.
Okay.
Take your time, see if you can figure it out.
Just hit the stop button and get it hot. There you go.
Thank you. Apologies, Your Honors. May I please,
I come help, but you don't want me to.
may it please the Court, my name is Kristen Nagana, and I, along with my co-counsel Megan Oliva, have the pleasure of representing Toho Water Authority, the employer and the servicing agent, who are, of course, the appellees in this matter. Your Honors, today we're requesting that this Court affirm all aspects of the Judge of Compensation Claims November 19, 2018 final compensation order. And, you know, with all due respect to counsel for the appellant, I think this is relatively easy for this Court to do. Now, we agree that both issues in this case, the one-time change issue and the misconduct or the TPD issue, present matters of fact and law. But I think it's clear from the judge's order that if you review it closely, you'll note that the judge correctly applied the legal standards pertaining to these issues. And by that I mean the one-time change statute and the misconduct statute. Therefore, it is our position that the only remaining inquiry for this court to make is whether competent substantial evidence supports his
Well,
ultimate
counsel made
conclusion.
a pretty convincing argument that he objected on the 18th. And in that objection, he also specifically said he still wanted Dr. Winters. And that was after you appointed Dr. Royce.
Correct.
So you were aware at that point that he was still not happy with Dr. Royce.
Certainly.
And it seems to me that from a policy standpoint on workers' comp, he made the argument that his client, if he was hurt at that time, was hurting and wanted treatment, could have either gone to Dr. Winters, in which case he might have gotten hit up for the cost, or gone to Dr. Royce at that point. So aren't we if we require something more than lodging an objection, aren't we putting a claimant in a pretty bad position?
Your Honor, I don't think so, respectively. First, I agree with the timeline as articulated by you, during the appellant's argument and here now. There was a request, there was a petition, there was an authorization of Dr. Royce within 3 days of that petition, and then there was an appointment letter sent out promptly after the appointment letter. Counsel for the appellant, the claimant, wrote his objection and specifically said, Your Honor, we are not accepting Dr. Royce as the physician. Instead, I'm going to be sending, or my client will be going to Dr. Tom Winters under the self-help or parati provision. And that, of course, enables an injured worker to go to a physician of his own choosing if the judge of compensation claims later finds that treatment was wrongfully denied. And then that physician becomes authorized as a matter of law for the period of wrongful denial. But however, Your Honor, that did not occur, of course, as you noted. Instead, the claimant went to Dr. Royce on 2 occasions, and there's testimony, and I'm not sure, Your Honor, I think you're correct, the date of the first appointment might not be certain in the record, but there's testimony at trial by Mr. Krysiak, I believe page 96 of the trial transcript, in regard to his going to 2 appointments with Dr. Royce. That was in April, and the last one was in May. So, Your Honor, in this occasion, and, really, Chapter 440, workers' compensation, is a remedy available to injured workers, right? The one-time change statute provides injured workers an opportunity, if they don't like their first physician, to request a new physician. Now, there's a case articulated in my brief that certainly there's no guarantee that the claimant will be happy with either physician, but those are the physicians he's dealt with. Now, that 44132F provides an opportunity if the one-time change isn't timely responded to, the claimant has the option of selecting his own doctor and going to that doctor and choosing the doctor. However, the cases that I believe are on point, and those are the Pruitt cases, these Ikonovich cases.
Okay, the Pruitt case waited 2 years.
I'm sorry?
I mean, you just said Pruitt, right?
Yes, sir.
Pruitt case waited 2 years, and they did not name another doctor there. So Pruitt's not on point, is it?
Well, I don't think, certainly, Your Honor, it's not factually on point, but I think the important analysis contained in all 3 cases and the dispositive inquiry that was made in all 3 cases is, regardless of the objection and whether an objection was tendered, did the claimant go to the appointment? Did the claimant avail himself of the benefit afforded by, Chapter 440? And he has the option of doing that. He doesn't have to do that. But I believe if he does, if he avails himself of the benefits provided by the employer, and that's a point I want to make sure this court is aware. At no time was the claimant in this case without authorized medical treatment. He was provided the first physician, then he requested a one-time change, and once that one-time change was unobscured, unambiguous, as our position, that was the first time raised in the March 27, 2008 petition, another doctor was timely authorized, and the appointment letter went out within a couple weeks of that.
This whole idea of that unambiguous, and I know that the JCC didn't rule on this.
Right.
Well, you guys didn't do anything to clear it up. You just sat on it. Both the attorney and the adjuster neither said, okay, we're not clear what you want here.
Mm-hmm.
Doesn't the employer have some responsibility at that point to do something?
And, Your Honor, I think this was articulated below. This is all, I think all parties will agree, and I'm sure this court will agree, workers' compensation is a creature of statute. And I think to the extent there's shifting responsibilities, that is limited to what's set forth in 4401332F.
It's a creature of statute, but you don't have to cite a statute to get the remedy. especially, in this case, he was represented by an attorney,
Correct,
but it's supposed to be a self-executing system.
correct.
So if the attorney specifically, if patient specifically asks for a new physician, doesn't the carrier have some responsibility at that point to move ahead and find out, is this the one-time change that you want?
Well, first, Your Honor.
I'm really having trouble buying the carrier's argument on that point.
Well, in an ideal situation, Your Honor, perhaps that would have occurred, but I don't think there's any responsibility set forth by either the statute or the case law on that. And I'll say, Your Honor, of course, I know one of the primary arguments below was that the request was phrased as an alternate physician, which the adjuster, of course, testified to why she didn't accept that as a one-time change. It doesn't cite the statute. It wasn't clarified as a one-time change because these adjusters get things in and, they're trained in a certain way. And so they usually, when they get a request, they are required to authorize a one-time change
They're trained to ignore it?
No, Your Honor, but they're before you authorize a one-time change, which is only provided once per injury, once per accident, it needs to be absolutely clear that that is what's being requested.
Okay, I'm not going to get into an argument. Let's move on to some other stuff.
Okay, Your Honor, sure.
Okay, convince me why the law on deauthorization should not be applied under these circumstances.
Yes, Your Honor, of course. Well, first, the Crenshaw cases, the Cal Covens case, and the Stuckey case, obviously that applies to the deauthorization statute that's no longer in existence. This is a older procedural scheme that.
I understand, but what about that scheme is such that we should not apply it to this particular case? You made the argument it's different. Yes, it's different, but what makes it different that we should not apply the law from that to this?
Well, first, Your Honor, I think you have to examine what goes on in the deauthorization process, because that is why the objection, the dispute in deauthorization is so pivotal versus here, where I think it's more about did the claimant attend the appointment, okay? So in deauthorization, that occurs when a carrier decides or is unhappy with the current doctor for whatever reason, and then authorizes a new doctor. So this is a process started by the carrier versus the claimant, all right? So then, if the claimant disputes it, the carrier then has an obligation to get an order from the judge of compensation claims, basically allowing the carrier to deauthorize the doctor and authorize a new doctor. So this is all first started by the carrier and really hinges on an objection by the claimant. In this case, this is obviously a request generated by the claimant to change doctors, and if you look at the cases that are specific to the one-time change statute, 44013-2F, that entirely hinges on did the claimant attend the appointment. Like you noted, there was the objection, but after the objection, the claimant still attended the appointment. And that is provided for, Your Honor, in the Pruitt case, which I know is factually distinguishable, but still, I think supports our argument. The Gona case and then the Zaganovich case, where it talks about a claimant might object, but then subsequently accede to the carrier's choice.
Okay, but in both those cases, they did not name a specific physician that they wanted to see, did they?
Well, I think there are different, Your Honor, in terms of, whether physicians were made. But again, I think if you look at all three cases, well, of course, Pruitt did not, I don't think Pruitt ever named another physician.
Pruitt didn't, I'm not sure the other two cases.
No, and I believe Zaganovich, they did name. He did name another physician, but he didn't go to any appointments with the carrier's doctor. So, again, I'm not sure I don't place as much emphasis, and I'm asking this court not to place as much emphasis on the objection because, again, it was tendered, but then he still goes to the appointment. I think these cases are clear that when they're interpreting the actual statute that's in existence now, it is all about did the claimant go to the appointment. And that, Your Honor, is why I think the judge properly relied on those cases versus all the cases under the deauthorization standard.
Usually when we talk about acquiescence and waiver, we're talking about somebody really knowing what they're doing. Does somebody really know that they're waiving it when they continue to ask for another physician? Should we impose a waiver on a claimant who's still objecting to seeing this physician and still seeking another one? You understand my question?
I think so, Your Honor. So basically, you're saying that even if the claimant goes to the other appointment, he shouldn't be. I mean, that's basically not enough. You're saying
waiver is usually a knowing voluntary action.
Right. Okay. Well, and
I'm saying here that it's really not know. I mean, he knows he's going to the physician, but he still thinks he has an objection lodged to going to this position.
Sure.
So should we, as a matter of law, impose a waiver in those circumstances?
I mean, I think so, Your Honor, just because that's how I read the cases. I mean, certainly, and, it's just it's a risk you take, I think, and I just don't see any other interpretation of these cases by saying, look, and, he's represented by counsel the entire time. You're very...
You say it's a risk we take. Why should we make a claim and take that risk?
Well, Your Honor, like I was saying earlier, that's, the risk you take are basically the rules maybe not the risk, the rules you have to follow when you're availing yourself of the benefits afforded by Chapter 440. You don't have to see the doctors authorized by the employer, but if you do, I mean, this is an elective remedy. If you do, there are certain rules you have to abide by, and that's set forth in the statute and the case is construing it.
Okay, let's get to the second point, because we're running out
Yes,
of
sir,
time.
of course.
Help me here, because it seems to me the trial judge said, or the JCC said it a number of times, I'm not using this for the purpose of this being a negative result to prove that he was under the influence at the time. I'm only letting this come in to show the state of mind of everybody. Yet, at the same time, he said that when he issued his order, he says, okay, I'm basing it on his absences, his appearances, and the negative test results.
The positive
to demonstrate
test
he's
results.
under the influence. So isn't that specifically what he said he was not going to do?
Well, Your Honor, I think you have to take the objection one by one. I agree objections were raised in the testimony. The first time an objection was raised was when the claimant was testifying and he was presented a memorandum that had been given to him by the employer that I think might have referenced the test results. And the judge says, I'm not going to allow, the claimant to testify about these test results, but you can have him talk about it and his actions in response to that. The next time there was an objection was in response to a question posed to Ms. Rebecca Martinez, who's the employer representative, about whether she had received the test results. And that was an objection based on hearsay. And that was not a correct objection because obviously, whether or not you received a test result is not hearsay. She goes on to ask about the results of it. Or she was asked about the results of it, and she said they were positive. And there was no objection to that. There was no motion to strike, and she proceeded on
but
from
when
that.
the judges previously said, I'm letting it in for one purpose.
Well, letting what in, Your Honor? Because, again, I think the information that was asked was different from the claimant than versus...
Well, no, as I read the transcript, though, the three times the JCC said in relation to test results ahead of the fourth time where it came up, I'm only going to allow it as to state of mind, which as an ancillary point, I'm not sure what state of mind had to do with anything here, but that aside, why wouldn't the claimant's counsel believe the court had made its determination, and why am I going to keep disrupting this process? As counsel pointed out during his argument, we have the fact finder in front of us, and he's told us where he stands on this. So why would that not be futile to make a fourth objection?
Well, I mean, in my practice, I'm not certainly going to cast aspersions on anything anyone did, but I think it's important, as Judge Kelsey mentioned earlier, to get a standing objection, file a motion in limine before the hearing, say, Your Honor, I want, all evidence as to test results that are not in evidence stricken. I think there has to be, in response to that, some, that we know what they're objecting to. Certainly the judge made that finding as to what the claimant was testifying to, but I don't think he had made a finding as to what Ms. Martinez said. Otherwise, I think, Your Honor, that kind of goes to the misconduct
Well, I'd like to deal with that a little bit, and I know we're almost out of time, but
You have as much time as you like.
oh, thank you, Judge Wolf. That's very kind of you.
I won't ask.
I was a trial lawyer and a trial judge for a long time, and this is hard in real time to deal with these issues. And so we have a judge repetitively saying, I'm only going to allow it for this. And then it comes up again right after he just told everyone the only reason he's going to allow it. And you're saying that the failure to object at that point was waived. I'm just, trying to understand why that would not be, why everyone wouldn't fully expect the judge to do precisely what he had done 3 times before.
I mean, Your Honor, I think it's as simple as it was not raised again. It was not raised as a standing objection. And so while the judge, I think, ruled as to a specific objection, which again was correct, 2 questions, or was incorrect 2 questions prior, he had not ruled again on the specific question thereafter. And if I may address kind of an ancillary point as to why you said it was relevant to the state of mind, if you don't mind.
I'd like to hear that.
Okay, sure. Well, and, I'm not sure I agree with it being relevant to the state of mind as to the claimant at that point anyway. But I do think it's relevant to the employer because I think the judge articulated this misconduct standard, which is why I think he got it right in the order. He said part of the misconduct standard is did the employer actually terminate, were the grounds that led to the termination based on misconduct, okay? And I think that is set forth clearly in the Thorkelson case that I believe was cited by both parties. The second inquiry, and Judge Jay, I think that's where that inquiry comes in, what was the information the employer had that resulted in misconduct? The second inquiry is whether that information, those bases, meets the definition of misconduct set forth in 440218, and then, of course, mirrored in the unemployment. But, Your Honor, I think that testimony was appropriately admitted, even if it wasn't. That was just kind of, the latest in a string.
Okay, let's assume that it was admissible for the purpose
for
the purpose of showing why the employer dismissed this person. If that's the only reason it came in, I know you're not saying it was, but if that's the only reason it was allowed in, or should be allowed in, then what evidence was there that this person was actually under the influence on the job?
Well, I think, Your Honor, that's where you look at Rebecca Martinez's testimony. And
did she see him at all?
She did not, but she spoke with a supervisor, and that supervisor's testimony I do not believe was
Do we even have the details of what the supervisor said?
I don't believe there's the details, Your Honor, but Rebecca Martinez makes a point in her testimony about how supervisors are trained to monitor employees, look for symptoms of alcohol intoxication. Your Honor, this is not the first time that it happened. Of course, the first time that, really started the ball rolling with the termination was a year before when he was reprimanded for having alcohol in his car.
So the misconduct was the second time. I'm trying to find out under the policy of the company, it said they had to show that he was either in possession of, which he was not, or under the influence of. And I'm trying to discover, if you don't have the positive alcohol test, what really was put on the record to show that he was under the influence of alcohol.
Well, again, I think it's if you examine Rebecca Martinez's testimony, who again spoke with the supervisor, and that testimony came in, and he had concerns about how the claimant appeared, and there was testimony from her based on how they're trained. There's also testimony from the employee who suggested he had taken NyQuil or DayQuil. I see my time as well.
Are you under the influence if you take NyQuil or DayQuil the night before?
I'm sorry?
I've taken NyQuil the night before I've come on the bench. Is that a problem?
Well, no, but I'm saying, Your Honor, that was offered as an explanation by the claimant. So, and I know I'm well over my time.
No, that's fine.
Okay.
I will give you 30 seconds to conclude.
Okay. Thank you, Your Honor. It's not just, and I understand the court's concerns about the alcohol testing, but it's not just the alcohol testing. It started in June of 2016 with a reprimand for having alcohol in the car. It went on.
Okay,
and then,
it sounds to me rather than concluding, you're making an argument. Oh, your time's up.
Oh, okay. Thank you, Your Honor.
Thank you. I know I let the other side run, but I'm going to give you about a minute and a half, 3 or 4 minutes and a half.
Your Honor, just a couple brief points on rebuttal. With respect to the one-time change issue, the erroneous holding of the JCC in this particular case puts injured workers in a precarious position where they either have to forego authorized medical treatment or attend with the employer carrier designated physician at the expense of their one-time change physician, or the right to designate the one-time change physician. We believe that not only is contrary to the case law, but also implicates issues of due process. The claimant in this case has done everything he could to conform with the dictates of Crenshaw and all of its progeny. He objected to the employer carrier's conduct well before he ever attended with the physician. He named the physician of his choice. That was pertinent in the Goodall case, the Harold case, the Pruitt case. All of those reference whether the claimant named the physician of his choice. This case, the carrier shirked their responsibility to respond and designate a physician properly. In addition to the timeliness issue, the carrier cites that there could be some ambiguity issue, and what I would note was that they totally overlook a second email that was sent to claimant's counsel on March 20th. A one-time change physician was not designated by the carrier for another 10 days. So any ambiguities in the initial correspondence were essentially rectified by that second correspondence, and that was stipulated as received by claimant's counsel. With respect to Judge Wolf's question pertaining to whether the deauthorization cases should apply here, we would note they absolutely should. There is no appreciable distinction between the deauthorization cases and cases of one-time change. Here, we're dealing with deauthorization of a physician and authorization of a new physician, and a claimant contesting the propriety of that particular action under the Act. The waiver analysis should essentially be the same. Has the objection of the claimant been adequately conveyed to the employer carrier to place them on notice? The single factor test of an injured worker attending with a physician, which is essentially him trying to recuperate, him trying to receive medical treatment, cannot alone be dispositive in these cases. The practical ramifications of such a holding could be tremendous. In short, it could incentivize carriers to essentially employ a wait-and-see approach. Oh, well, you know what? We may be late on this one-time change request. Let's hold off and see if they attend with our physician. That places the claimant in a point where they're actually dealing with coercion. Medical treatment is being withheld. They have no option but to assent to the employer carrier's designation. And for that reason, we feel that in particular cases where an injured worker names their physician, objects to that, they should still be permitted to receive authorized medical treatment. The last thing I would note is that with respect to the misconduct issue, with respect to Judge Jay's comment as far as us raising these objections on numerous occasions, we had received definitive rulings from the judge more than 3 times that he is going to allow this testimony for the subjective basis. That question that they say that we did not preserve our objection to.
Give me an additional minute and a half. Your time is running. Thank you.
Thank you, Judge.
Thank you both sides for the excellent oral argument.
All rise.